Buckle up, guys. Today we are going to step inside a courtroom where confusion sets the tone from the very first seconds. A woman is told she shouldn't even be there, and suddenly we're dealing with interstate complications and paternity acknowledgement. What should be routine quickly feels tense as agreements are read into the record. But when money enters the conversation, you can sense hesitation building beneath the surface.
Ms. Castillo, you do not live in Texas, is that right?
I do not.
Okay, you're not supposed to be here. The AG might have sent you a letter by accident. This is an interstate case. So, Mr. Morales, you live in Texas, correct?
Correct.
Okay. All right. All right. So they're both present, Mr. Tatum. What do we want to do?
Your Honor, the state is requesting that the court take note that both parties did appear before the court.
I'm gonna note that Mr. Morales is present, but she's not required to be here. So, I
Yes,
guess
sir. Your Honor, this is a contested hearing. The parties agree that the child is currently receiving insurance through the state through the state of Louisiana for state medical. There's been no request for retroactive support. And the parties agree that the father shall be established as the children's father for all three children here in this matter. All other issues are contested, so we will need to take additional testimony as it relates to those issues. So at this time, Your Honor, the state would like to call the mother here in this matter. Ma'am, can I get you to state your name for the record?
Evangelina Castillo.
And did you hear what I previously read into the record that was agreed to by the parties?
Yes.
Are you still currently in agreement with those terms only?
Yes.
And as it relates to the children here in this matter, the state has used the father's income of $18 an hour at 40 hours a week to calculate support and will request that the father pays child support in the amount of $732 per month. Are you in agreement to that amount?
Yes.
And as it relates to medical support, again, based off of the father's reported income, the state is requesting that the father pays insurance in the amount of $250 per month. Are you in agreement to those amounts?
Yes.
All right. Do you have any additional information to offer to the court as it relates to the contested issue of child support and medical support?
No.
All right. Nothing further from this party, Your Honor. At this time, Your Honor, the state would like to call the father in this matter. Mr. Morales, can I get you to state your name for the record?
Luis Morales.
And Mr. Morales, did you hear what I previously read into the record that was agreed to by the parties?
Yes, I did hear it.
This is where patience runs thin. The judge is simply asking for clear yes or no answers, but the father keeps circling back to one thing. How much is the total? The court isn't even at the payment stage yet. The judge firmly resets the focus. Are you the dad? Do you agree? Stop interrupting. It's a powerful reminder that clarity in court isn't optional, it's mandatory.
Mr. Morales, only as it relates to the issues that were agreed to, which again is that the children are receiving insurance through an outside source, which is the state of Louisiana, and there's no request for retroactive support, and that you should be established as the father of the three children here in this matter. Are you in agreement with those terms only, sir?
Depends. How much is the total?
All right, Mr. Morales, are you the father of the children here in this matter?
Yes.
And Mr. Morales, are you in agreement to the request that there be no billed retroactive support?
Oh, yes. For
And
the
are you in
back. Yes.
agreement that the children are receiving insurance through the state of Louisiana?
Yes.
So again, sir, you are in agreement with those terms only, is that correct?
Just for the first couple.
Mr.
Moving
Morales, you
forward.
need to listen to the question. He's asked you twice the same thing. You agree with those three things, yes or no? And you keep saying no, yes, no.
Oh, those three things. The last one about the reason is I asked how much is that? How
I'm
much is
not
the
skipping
total amount
ahead.
gonna be?
I don't know why you're skipping ahead. No
Oh,
one asked you about
yes.
the contested issues. We're trying to do the easy part.
Okay.
The easy part is that we think you have three agreements. He's just trying to confirm the three easy parts. He's done it twice to ask you the questions, and you haven't really answered it, other than it sounds like you don't agree with it. I don't quite understand what the disconnect here. We haven't gotten to the difficult issue yet. He's not asking
Oh,
you about
okay.
child support or medical support. He's asking, are you the dad? Do you agree that there's
Yes.
insurance through
Okay.
another state? Stop interrupting me because you're not listening. Are you the dad? Are you okay with the other state having medical insurance? And you okay with you not owing back child support? Yes or no?
Yes.
Okay,
I
that's
agree
the
to it.
easy part. Just a yes would be good. Okay, then he's gonna ask you questions about the contested parts. But I gotta get this easy part, or maybe you say I don't agree to anything at all. then let's talk. Then we start all over again. Do you understand what I'm saying?
Yes, yes, sir.
Okay. All right, Mr. Tatum, go ahead.
Thank you, Your Honor. And sir, you are currently employed, is that correct?
Yes,
And is that at $18 an hour at 40 hours per week?
yes, sir.
Because now reality hits hard. The total, $982, gets calculated, and you can almost feel the weight of that number sink in. The father admits it's his first time navigating this system. He worries about paycheck deductions, taxes, and whether a second job will also be garnished. Beneath the legal language is a very human fear. How do I survive and still be present for my kids?
You have no additional children outside of this case, is that correct?
No,
And sir, just confirm you stating that you do not have any additional children outside of this case, is that correct?
I don't.
Okay,
I
thank you, sir.
yes,
And as it relates to the medical support, based off of your current income, the state is requesting, sir, that you pay insurance in the amount of $250 per month. Are you in agreement to that amount?
250. That's fine.
All right. And as it
Yes,
relates
sir.
to the, thank you, sir. As it relates to the child support, based off of your current income, the state is requesting, sir, that you pay child support in the amount of $732 per month. Are you in agreement to that amount?
That's fine. Yes, sir.
So just to confirm, sir, you do agree to paying the child support and the medical support as provided to the court today?
Yes, sir. That's
All
fine.
right. All right. Nothing further from this party, and it appears that we have a fully agreed order.
Okay. Do you understand everything we're talking about, Mr. Morales?
Yes, basically, it's okay for me to speak. I'm.
Well, do you understand everything? That's what I'm trying to find out first.
Oh, somewhat,
Okay.
somewhat, because I'm sorry, sir. I didn't know if you were going to say something or not.
Well, I was going to ask you, what is it you don't understand?
The end part is 250 plus 732, and how much would that be? And this is my first time. That's why.
I don't know. I got to get a calculator just like you do. I don't know.
New case, new tension. A mother insists there's no family violence, yet she fears retaliation once support increases. Her concern? CPS reports. The judge draws a sharp legal line. CPS involvement is not the same as family violence. The request to hide her address is denied. It's a clash between emotional strain and strict legal definitions, and the court won't blur that boundary.
982.
982, and that's every paycheck, or they break it up in two paychecks since I get paid bi-weekly.
Yeah, they'll break it up into your paycheck. So it won't come out all of one paycheck. It'll be like a portion out of each paycheck, roughly about half, but it's a little bit less than half per paycheck if you get paid bi-weekly. And it'll just come out of every paycheck.
Okay, but that's besides the taxes and the federal and everything.
It'll come
So
out like the
basically,
taxes. It'll come out like the taxes. It'll just come out of your check and you won't receive it at all. It'll just go straight to
okay,
child support.
so I go to child support. Okay, so and I got one more question. I got another job since I go pay child support, since I have to live my life and I have to save some money so I can visit my kids because they live 7 hours away, and I want to make sure I have the extra money to visit them. If I don't have the money, then it's gonna be hard for me to visit them. So I just want to make sure they ain't gonna take no money off for my second job.
They shouldn't need to as long as you have enough paid out of your first job. So if
Okay,
you're paying the full amount out of your first job, sometimes what happens when people have two jobs is send that withholding order to both jobs to take the same amount out of both jobs. And so as long as you're paying through the one job, if you get a letter for the second job or they take it out of your second job, then you need to call the AG's office and complain and say, hey, you're already taking out of one job. I don't need to take it out of both. And then they can correct that. But so if you have that problem, you can call them back and tell them that. But as long as you're making full payment out of one job, then we should be good. All right. The Attorney General's office is going to put that in writing, email you both a copy. Y'all are done with court. You can press leave on the Zoom to exit out. Thank you.
Thank you,
Thank
Honor.
you. Charlemagne Carbs.
And the name of the child or children that we're here in reference to,
Her name is Clarissa McGee.
and the name of the child's father.
Durante McGee.
Because now the courtroom tackles control and procedure. The judge makes it clear Prior orders stand unless properly challenged. You can't quietly rewrite custody rules in a support hearing. The mother argues years of CPS disruption, but the court emphasizes documentation and due process. It's a reminder that frustration doesn't override formal legal steps.
Okay. Just one moment. And has there been any issue relating to family violence between you and the other party to this case?
Not family violence, just what's the word I'm looking for? Disruption.
All right. Are you currently in fear of your safety or your child's safety?
No,
All right. As it relates to your address, does the other party have that information?
he does, but I'm about to move, and I don't want him to have that. My next address.
All right. If there is no current family violence and there has been no prior family violence and you're currently not in fear of your safety or your child's safety, is there any specific reason why the father should not have your address going forward?
Because he's going to call CPS once the child support goes up, and I don't want to fight that.
All right. And the state has used the father's previously reported income at $2,761 per month for the calculation of support, and will request that the father pays child support in the amount of $465 per month. Are you in agreement to that amount?
Yes, sir.
And as it relates to the insurance, how does your child currently receive insurance? Is it through the state or through your employer?
It's through the state.
And based off of based off of the father's reported income, the state is requesting that the father pays insurance in the amount of $75 per month to begin on February the 1st, 2026. Are you in agreement to that amount?
Yes, sir.
And are you in agreement to the father paying the court costs associated with today's hearing?
How much is the court cost?
Whatever is billed by the court, ma'am. Are you in agreement for the father to pay it, or are you requesting that we attribute that to you, ma'am?
He can pay it.
All right. Do you have any additional information that you would like to offer to the court today?
I would like to lift the geographic restriction.
And ma'am, do you understand that that issue is not properly before the court today?
No, sir, I wasn't aware.
All right. Nothing further from this party owner.
This one seems smooth until it isn't. A temporary agreement is reached, split custody continues, and support stays at 0 for now. But when insurance comes up, the father admits he doesn't know enrollment details, costs, or deadlines. The judge presses him firmly, get it done or face medical support orders. Responsibility isn't theoretical. It comes with deadlines and consequences.
All right, default judgment granted. I'm not granting your request for non-disclosure. Your prior order ordered you both to share your address information. There's been no family violence since then. And so he's entitled to know where you live. Anytime that you move, you are supposed to notify each other of your new address.
What?
If you have a geographic restriction now, you have to follow that order. You cannot change it until you go to court and get it changed. The AG's petition that they filed today did not include that request, so you'll need to file that on your own or talk to the father and make sure he agrees to that if that's something y'all want to agree to. But I'm not doing those extra things here. There's no need for that.
But you haven't been the one constantly fighting CPS for the past 14 years either.
CPS is not family violence, ma'am.
No, but it's distractive of my family and my
I
household.
understand. I'm sure they keep a record of it and all the false claims that he makes, but they've got to still do their job. And if there's no reason to worry about you or your child, then they're going to dismiss their thing. I mean, that's not family violence.
Yes, sir.
Okay.
Okay.
All right. The Attorney General's office will put that in writing and email you a copy, send out a new withholding order. You're done with court today. You can press leave on the Zoom to exit out. Thank you.
The parties agree that they currently have a split possession schedule with the child, with the mother having the child on Mondays and Tuesdays, and the father having the child on Wednesdays and Thursdays, and they both rotate on the weekends each week. The parties agree for this to continue, the schedule to continue into the future. The parties agree to the setting of child support currently at $0. The parties agree that the retroactive support will be reserved for the final hearing. The parties also agree to address conservatorship at the final hearing, and that as it relates to the insurance, the child is currently receiving insurance through the state, but the parties agree to the father carrying the insurance going forward. The parties are requesting a reset to allow time for the father to get the child covered through an outside source for the insurance for the child.
Because delay becomes the headline here. No service on the alleged father. No notice properly filed. The mother is clearly exhausted by repeated resets. The judge shifts tone, stressing urgency. These aren't toddlers anymore. These are older kids waiting for clarity. The system can only move as fast as cooperation allows, and right now, cooperation is missing.
I believe that is the extent of the agreement. So at this time, Your Honor, the state would like to call the mother in this matter. Ma'am, can I get you to state your name for the record
Venezuela Brown Newton.
and the name of the child or children that we hear in reference to,
Rocket St. Lawrence.
and the name of the child's father?
Stanton Lawrence.
And did you hear what I previously read into the record as it relates to this matter?
Yes.
And are you in agreement with those terms that were previously provided to the court?
Yes.
And are you in agreement for this to be a temporary order?
Yes.
And are you in agreement to address all issues that were not addressed today in that final hearing?
Yes.
And are you in agreement to return back to the court on February the 26th, 2026 to address all issues not addressed today?
Yes.
All right. Do you have any additional information that you'd like to offer to the court today?
No.
All right. Nothing further from this party. At this time, Your Honor, the state would like to call the father here in this matter. Sir, can I get you to state your name for the record?
Stanton Lawrence.
And Mr. Lawrence, you are the father of the child here in this matter, is that correct?
Correct.
And did you hear what I previously read into the record as it relates to this matter?
Yes, sir.
And are you requesting that the court accepts those agreements and make them part of the order today?
Yes.
And are you in agreement for this to be a temporary order and for us to return on February the 26th, 2026 to address all other issues not addressed before the court today?
Yes.
And are you requesting that this matter be reset with this temporary order to allow you time to get the child covered on the insurance through an outside source?
Yes.
All right. Do you have any additional information that you'd like to offer to the court today?
No.
Nothing further from this party, Your Honor.
Now the pressure intensifies. The judge openly questions the father's intentions. If he's the dad, step forward. If not, demand DNA. But the clock is ticking, and childhood doesn't pause for legal strategy. The court makes it clear this case needs movement, not avoidance. Accountability isn't just financial, it's about presence and truth.
All right, temporary order is fine. I'm not sure about the reset date. Mr. Lawrence, are you providing insurance through your spouse's insurance, or are you going to go look for private insurance, or you have insurance at your
I have
job?
insurance. I'm just gonna add them to mine.
Okay, is it your enrollment period, or is it that you need a copy of the court order to enroll the child?
I'm not 100% sure.
Okay, you don't know if it's your enrollment period right now?
I'm not sure.
Okay, but you do have it available at your job at a reasonable cost.
No, I just know I have insurance. Yeah, I'm self-employed. I'm self-employed, but I have insurance, and I'm gonna add him to it.
Okay, but do you have any idea how much it costs to add a child?
I have no idea how much it costs to add him.
Okay, all right then. All right, we'll leave the same court date. Reset to February 26th, 2026, 9 o'clock. You need to get an insurance card. Obviously, today, you need to get the insurance enrolled for the child. It's going to take a little bit. That's about a month and a half from now to the next court date. So don't wait until the week before court. As soon as you get an insurance card or some kind of verification, you need to provide Ms. Brown Newton a copy of the insurance card, and then scan it so you can show the AG when you come back to court on February through your computer that you have insurance for the child. Okay.
All right.
All right. If you don't do that, I may have to put you on for medical support. So I'm sure that's what you're trying to avoid, but you got to get on getting the insurance since y'all are doing this split. All right. Y'all are done with court. They will email you a copy of this order if they have your email address. Should be signed either today or tomorrow, so that you should get it pretty quickly if you need it. But if it sounds like you're self-employed, so you may not need it. But they'll send you that just in case. All right, you're done with court. You can press leave on the Zoom to exit out. Thank you. All right, Damone Manning and Desiree Wilson, please unmute and turn on your cameras. And Mr. Carpenter, you represent Mr. Manning?
Yes, good morning, Judge. Can you hear me?
Yes. Is he present?
No, Judge, he's not. There's not been any service on Mr. Manning,
You
And
filed a notice of appearance?
yes, I believe I did file a notice of appearance, and I've just been kind of monitoring the case. This is the third. I believe this is the third setting on the case.
I don't see any notice of appearance filed by you.
Oh, you don't? Okay, I'm sorry. I thought I'd done that because I've been here each time. I can do that, Judge. I'm sorry. I thought I'd already done it.
Because this case flips the script. Both parties agree smoothly to joint conservatorship and set support amounts. Then comes an unexpected moment. The father voluntarily promises to increase payments once he secures a better job. That's rare. The judge explains how they can modify the order later. It's a glimpse of cooperation over conflict, and it stands out sharply.
Okay.
So that. Oh, I'm sorry.
I was going to ask Mr. Tatum, what are we doing, Mr. Tatum?
Your Honor, so we do not have service on the non-custodial parent in this matter, and the attorney, as he stated, is refusing to accept service on behalf of his client. So the state is requesting that this matter be reset to allow us time to hire an attorney. To get the service done on the father.
And Judge, since I have not filed an appearance, I guess I will not oppose that reset, and I'll get a notice of appearance on file.
Okay, we need to get him here.
Yes, Judge, I'll do what I understand, Judge. So I'll get my notice of appearance.
Okay.
Thank you, Judge. Good to see you. Oh,
hold on, we're almost done.
AG.
Okay, Mr. Tatum, what reset date did you say?
Yeah, the state is requesting that this matter be reset to return on February the 26th.
Okay. February 26th.
Okay, Ms. Wilson, I understand you probably want to get done today. I remember the name, so I'm sure I've seen you before, but there's still no service on Mr. Manning. And so I can't really do too much until he's served. Did you have something else to tell me besides
I have is, I can't keep on resetting this. I work. He's at work just right now. He works with his dad. I got the address where he works. He works in Arlington. I cannot continue to do this.
Okay.
I have a job just
I
like
don't-
he got one.
I don't work for the Attorney General's office, so after you leave court today, if you want to call them up, if you haven't already given them that information or they don't have that yet, then give them a
Yes.
call and give
They
them
have it.
information. Give them that information so they can send it out to the process server. Once they send it to the process server, they don't have control over it, so they'll tell them what you told them as far as what the address is that he can be found at. Might be helpful to know about around approximate times that he's there. If you know that, like if he works 8 to 5, there's no point to serve him at home between 8 and 5. But you can kind of give him that, or you know where he works. You can definitely call the AG's office after court. I don't control that. I'm just the judge, so I don't know about that part. But they will be submitting that to the process server, and then it's on the process server to go serve him. Okay. All right, then we'll reset to February 26th for our next hearing. Hopefully there'll be some movement. Mr. Carpenter, we need to get moving on this case. I don't know what Mr. Manning's intention is here. We got some old kids here on this case. If he's a dad, we need to figure out if he's a dad, and if he is a dad, he needs to start visiting and paying support. So we need to get moving. I don't know why if he's delaying service, then he needs to come forward and we need to find out because that's some old kids. And if he's not the dad, then we need to go find out who the dad is because
All right.
older children here.
Is this a capture or a modification? I don't even have a copy of the pleading, so I'm not sure what's on what the AG is trying to do.
It's both. We had to have 2 children, one born in 2008.
Okay.
That one's a paternity. And we have another child born in 2010. That one's a SAPSR. He's on acknowledged paternity for that one. So
Okay.
definitely that one he should be paying child support for. If he wants DNA for the DeMonte, the oldest one, he needs to do that if he wants to do that. I'm not sure if he wants to. It's an older child. That's might be different. But he has the ability to do DNA testing if he chooses. But we have older kids here, so we need to move here. We're talking about 3 or 4-year-olds anymore.
I'll reach out to him and I'll let him know what the court's position is.
Okay. All right then. Thank you.
Yes.
Y'all are excused. You can press leave on the Zoom to exit out. Thank you.
All right, Judge. Bye-bye.
The state is requesting that the court take note that both parties did appear before the court.
So noted.
Thank you, Your Honor. The parties agree that there has been no issues relating to family violence. There is no request for a non-disclosure. that the non-custodial parent is currently unemployed and the child is currently receiving state medical. The parties agree to be named as joint managing conservators with a standard possession order with no geographical restrictions. Again, the custodial parent to provide insurance through the state. Child support to be set at $210 to begin on February the 1st. Medical support to be set at $113, also to begin on February the 1st. There's no request for retroactive support. Court costs billed to the non-custodial parent. I believe that is the extent of the agreement. So at this time, Your Honor, the state would like to call the mother here in this matter. Ms. Arteaga, can I get you to state your name for the record?
Alexandria Arteaga.
And the name of the child or children that we're here in reference to?
Adelina Olivares. Sorry.
And the name of the child's father?
Aiden Olivares.
And did you hear what I read into the record as it relates to this case?
Yes.
Are you in agreement with those terms that were previously provided to the court?
Yes.
Are you requesting that the court accepts those agreements and make them the order of the court today?
Yes.
Do you find these agreements to be in your child's best interest?
Yes.
Do you have any additional information that you'd like to offer to the court today?
No, I do not.
All right, nothing further from this party, Your Honor. At this time, Your Honor, the state would like to call Mr. Aiden. Mr. Aiden, can I get you to state your name for the record?
Aiden Olivares.
And Mr. Olivares, did you hear what I read into the record as it relates to this case?
Yes.
Are you in agreement with those terms that were previously provided to the court?
Yes.
Are you requesting that the court accept those agreements and make them the order of the court?
Yes.
And do you find these agreements to be in your child's best interest?
Yes.
Do you have anything additional that you'd like to offer to the court today as it relates to this case?
Yes.
And what is that, sir?
As of now, like before the question you just asked, if that's going to be okay for the child, as of now, yes. But as soon as I get another job, I'm willing to come back and increase that value of the child support as needed.
All right, thank you, sir. Nothing further from the state, Your Honor.
All right, I will approve the agreement y'all have made today. The Attorney General's office is going to put all that in writing into a court order for me to sign, and they will try to email you a copy. Definitely, if y'all you get a job, Mr. Olivares, or making more than what you're making now, you can definitely meet with the AG's office outside of court, and they can do an agreed order and just submit it to me without you having to do a court hearing, if that's something you want to do. But for now, this is what we're going to do for this court order now, as we are right now, and then later on, you can both contact the office to set up that kind of meeting once we know. All right, y'all are done with court. You can press leave on the Zoom to exit out. Thank you.
Thank you.
And Mr. Tatum, you said that's a DNA test request?
Yes, Your Honor. The state will request that the court take note of the prior service of the non-custodial parent. The non-custodial parent was served in jail, and as a result, Your Honor, the state is requesting that this case be reset for DNA testing to return on March the 11th, 2026.
All right. I'm granting a DNA test order. We'll reset to March 11, 2026 at 9 o'clock here on Zoom. Ms. Parson, they're going to send you information about where to go do your DNA testing the next couple of days. So do your part to take the child and your child to the testing, and then they'll try to send somebody out to the jail to get him tested there. And that's all we need to do. Hopefully, if everything goes well, we get all the samples and the results. Hopefully, we could finish in March. Sometimes we have some problems with the jail and it takes a little longer sometimes. So we'll hope for that, but we'll see you back in March and see what the status is. Okay.
Okay, and I'm sorry. I've been going through this for a while, but I know they signed him up because my kids get Medicaid. Is that like what's going on here once they establish fraternity? Is it just going to be for their Medicaid, or I just want to know a little bit of the basis if I can.
Well, that may be one of the reasons why your case got referred to the child support office. If we can get child support out of him, that's what we're going to set. It depends on whether he's incarcerated or not. So
Okay.
if he's not in jail, then he has a financial obligation and financial duty to support his child. But obviously, if he's in jail, that may change things. Okay.
Okay.
All right, then. We'll see you in March. You can press leave on the Zoom to exit out. Thank you.
We close with uncertainty. A father served while in jail. DNA testing ordered. Financial obligation depends on incarceration status. The mother asks what this means for Medicaid and support, searching for clarity after a long wait. The judge sets the next date, but the real answer lies in pending results. If you found this breakdown helpful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.